very warm welcome to Thorough Newspaper Analysis for 24th of March, which is brought to you by LawSikho. Now let's start with today's agenda. Pehle to we are going to take up some important national and international news updates. This is going to be followed by a legal news update, which is a decision of the Honorable Supreme Court. And at the very end, we have an editorial to discuss, the title of which is After Rahul's Conviction. इस editorial में essentially हम इस चीज़ पे बात करेंगे कि once a lawmaker, be it an MP or an MLA, has been convicted of an offence, तो उनकी disqualification के respect में constitution या फिर किसी और law में क्या क्या provisions हैं. With this, let's start with today's TNA. तो सबसे पहले जो हमारे पास the first update that we have, it is coming from the field of sports. हाल ही में इंडिया के सरबजोत सिंह, he has gotten the gold medal, and Varun Tomar, he has made the country proud by becoming the third position holder, a bronze medal in the men's 10-meter air pistol event at the ISSF Rifle and Pistol World Cup in Bhopal, Madhya Pradesh. अगर हम women category की बात करें तो Chinese Li Zhu, she has gotten the gold medal, while Germany's Doreen Wennekamp has settled for the silver medal. The third position has also been taken by China. Coming to the next update, this is with respect to the unveiling of the Bharat 6G vision document. हाल ही में प्राइम मिनिस्टर नरेंद्र मोदी ने इस डॉक्यूमेंट को अनवील करते हुए ये बताया है that India is gearing up to roll out high-speed 6G communication services by 2030, and it has set up a Bharat 6G project to identify and fund research and development of the next generation technology in the country. ये अगर हम इस प्रोग्राम के इम्प्लीमेंटेशन की बात करें तो दिस इज़ अ 2-phase प्रोग्राम. पहला फेज़ स्टार्ट्स विद दिस ईयर एंड इट गोज़ अप टू 2025, जबकि जो सेकंड फेज़ है वो 2025 से 2030 तक चलेगा. सेंट्रल गवर्नमेंट ने एक एपिक्स बॉडी, एक एपिक्स काउंसिल भी सेटअप किया है जिसका पर्पज़ है टू ओवरसी द प्रोजेक्ट एंड फोकस ऑन इश्यूज सच एज स्टैंडर्डाइजेशन, identification of the spectrum for 6G uses, create an ecosystem of devices and systems, and also arrange for the requisite finances for resources for research and development of this particular project. Moving on to the next update, this is with respect to the celebration of the commemoration rather of Shaheed Diwas on 23rd of March. This is done in the memory of the three brave freedom fighters of India, भगत सिंह, सुखदेव थापर एंड शिवराम राजगुरु, जिनकी एग्जीक्यूशन हुई थी इन 1931. इस पर्टिकुलर डे का अगर हम सिग्निफिकेंस या इसकी हिस्टोरिकल बैकग्राउंड को जानें तो भगत सिंह, सुखदेव थापर एंड शिवराम राजगुरु ये 3 मेंबर्स थे हिंदुस्तान सोशलिस्ट रिपब्लिकन एसोसिएशन, जो कि एक रेवोल्यूशनरी ऑर्गेनाइजेशन थी जिनका जो कि एक्सट्रीमिस्ट फिलॉसफी में बिलीव करती थी, और उनका मानना था कि अगर हम ब्रिटिश रीन को अगर हमें चैलेंज करना है तो वी हैव टू मेक यूज़ ऑफ आर्म्स. And then let's understand how the events unfolded which led to the execution of these 3 brave sons of India. See, लाला लाजपत राय ने एक protest, peaceful protest organize करवाया था when Sir John Simon visited Lahore on 30th of October 1928, and इसी protest से निकल के आया the famous slogan Simon Go Back. हालांकि ये प्रोटेस्ट एक पीसफुल प्रोटेस्ट था, हावेवर सुपरिटेंडेंट ऑफ पुलिस जेम्स ए स्कॉट, उन्होंने लाठीचार्ज ऑर्डर कर दिया एंड एज अ रिजल्ट अनफॉर्चुनेटली इंडिया लॉस्ट लाला लाजपत राय. Now, in order to avenge the death of Lala Lajpat Rai, these 3 young revolutionaries, they wanted to kill James A. Scott. However, गलती से उन्होंने किसी और को मार दिया. Further, later on, उन्होंने प्लान किया कि जो लेजिस्लेटिव असेंबली है वहाँ पे वो बॉम्बिंग करेंगे जहाँ पे 2 लेजिस्लेशंस पे चर्चा हो रही थी. तो ऑन April 8, 1929 दे ट्राई टू बॉम्ब द सेंट्रल लेजिस्लेटिव असेंबली, बट अनफॉर्चुनेटली दे वर कॉट एंड उनके बाद दे वर ट्राइड एंड दे वर सेंटेंस्ड टू डेथ, एंड ऑन 23rd of March 1931 दे वर एग्जीक्यूटेड एट द वेरी यंग एज ऑफ 23, 24 and 22 respectively. Now let's move on to the next update for today. This is with respect to the QS World University Rankings by Subject of 2023. IIT-Delhi has entered the list of the top 50 institutions for engineering in the QS World Ranking, while Delhi University is the Indian university with maximum number of entries. Delhi University के नाम पे there are 27 entries, and this is followed by 25 entries in the name of IIT Bombay and 23 entries in the name of IIT Kharagpur. And now we've come to the international news segment with the worst update being World Meteorological Day. See, on 23rd of March, World Meteorological Day is celebrated every year. The same is celebrated to mark the official formation of World Meteorological Survey in 1950. It recognizes the crucial role of the national meteorological and hydrological services in ensuring the safety and welfare of the society. Another important update is with respect to the Abel Prize. देखिए Abel Prize essentially is equivalent to Nobel Prize in the field of mathematics, and इस year का जो Abel Prize है, this is being conferred on Louis A. Caffarelli. He is a professor of mathematics at the University of Texas at Austin, and the Academy of Norwegian Academy of Science and Letters has conferred or named him as the recipient of this particular prize. Norway's king is going to present the Abel Prize to Caffarelli, and he is the first Latin American mathematician to receive the particular award. With this, we've come to the legal update segment. हाल ही में सुप्रीम कोर्ट ने ये हेल्ड किया है कि subletting by tenant it is impermissible under the Bombay Rent Control Act unless the contract allows it. So the Honorable Apex Court has held that it would be unlawful, it would not be lawful to sublet after the enactment of the Bombay Rents, Hotel and Lodging Houses Rent Control Act of 1947 unless the contract expressly provides for the same. तो सी अगर हम सबलेटिंग का कॉन्सेप्ट देखें तो एसेंशियली उसका मतलब ये होता है कि सपोज इफ़ आई एम अ टेनेंट एंड मैं किसी प्रमाइसिस पे रह रही हूँ ऑफ द लैंडलॉर्ड, तो मैं अगर मेरा कॉन्ट्रैक्ट परमिट नहीं करता तो इन द एब्सेंस ऑफ एनी टर्म टू दिस इफेक्ट इन द कॉन्ट्रैक्ट मैं इस प्रमाइसिस को सबलेट नहीं कर सकती हूँ फर्दर किसी और थर्ड पर्सन को. And with this, we've come to the editorial for today, the title of which is After Rahul's Conviction. Now, at the very outset, let's understand the why of this article. तो essentially, राहुल गांधी को हाल ही में एक सूरत कोर्ट ने कन्विक्ट किया है in the 2019 defamation case, and he has been convicted to 2-year jail term. तो अगर इस हम केस की बैकग्राउंड को अंडरस्टैंड करें, सी essentially 2019 में जब लोकसभा इलेक्शंस हो रहे थे तो उस दौरान मिस्टर राहुल गांधी ही वाज organizing or hosting a rally in Karnataka, and उस रैली के दौरान he made certain comments, and I quote, he said, why do all thieves, be it Nirav Modi, Lalit Modi or Narendra Modi, have Modi in their surname, unquote. With this defamation, this proceeding, it was initiated against him, and finally this is the result of the same, that he has been convicted now. Now, in view of this conviction, let's understand the law governing defamation first. So, Section 500 of the Indian Penal Code, it prescribes for defamation a simple imprisonment for a term which may extend to 2 years or with fine or with both. Now, this is important. And also, as far as this conviction is concerned, we also need to understand that as of now, the court has accepted Mr. Rahul Gandhi's bail plea for a security of rupees 15,000 and has suspended his sentence for 30 days in order to allow him to appeal. Now, as far as disqualification of an MP or an MLA is concerned, तो हम इसकी जो law है उसको 3 fold उसमें divide कर सकते हैं. See, पहला तो let's have an understanding of which articles of the Constitution provides for the same. So, Article 102 Clause 1 and Article 191 Clause 1 of the Indian Constitution provides for disqualification of a member of Parliament and that of a member of Legislative Assembly respectively. So, अगर किसी MP की disqualification के respect में हमें provisions देखना है तो the relevant article would be Article 102. However, when it comes to the disqualification of an MLA, the relevant article would be 191. Now, these articles provide for certain grounds which are holding an office of profit, of being unsound mind, or being an insolvent, or not being a valid citizen of India. These are some of the grounds. Now, the second fold of legislation that we can see in this respect is the 10th schedule, which provides for anti-defection law. It provides for disqualification of the members on ground of defection. And thirdly, we have the provisions of the Representation of the People Act 1951. अगर हम थर्ड जो ब्रांच है जो which we discuss now, which is Representation of People Act, उसकी बात करें तो there are a lot of provisions जो कि different offenses की बात करते हैं and जो कि different grounds of disqualification की बात करते हैं. Now let's understand the first of which section is Section 9. It deals with disqualification for dismissal for corrupt and disloyal practices and for entering into government contracts while being a lawmaker. While Section 10 of this particular act, it deals with disqualification for failure to lodge an account of election expenses. A key provision, which is Section 11, it deals with disqualification for corrupt practices. Now let's come to section 8, which is relevant for our purposes also. So section 8 of this particular act, it deals with disqualification for conviction of offenses. This provision is aimed at preventing criminalization of politics and keeping tainted lawmakers from contesting elections. First disqualification जो इस particular section में है, it is for conviction under certain offences जो कि section 8 subsection 1 में listed है इस particular act के, and this includes specific offences such as promoting enmity between two groups, bribery and undue influence, and personification at an election. Also, the subsection 2 of this particular act, it lists offences that deal with hoarding or profiteering, adulteration of food or drugs, and for conviction and sentences of at least 6 months for an offence under any of the provisions of Dowry Prohibition Act. And lastly, which is relevant for our purpose, which is section 8 subsection 3, it states, and I quote, a person convicted of an offence and sentence of imprisonment for not less than 2 years shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years after his release. तो ये जो प्रोविजन है ये अट्रैक्ट होता है मिस्टर राहुल गांधी के केस में. नाउ लेट्स अंडरस्टैंड कि क्या कन्विक्शन कभी जो है वो रिवर्स करी जा सकती है एंड हाउ इट इज़ गोइंग टू ऑपरेट. सी कन्विक्शन डिस्क्वालिफिकेशन क्या वो रिवर्स करी जा सकती है एंड हाउ डज इट ऑपरेट. सी डिस्क्वालिफिकेशन कैन बी रिवर्स इफ़ अगर कोई हायर कोर्ट जो है वो स्टे ग्रांट कर दे ऑन कन्विक्शन, या फिर इफ़ द हायर कोर्ट डिसाइड्स द अपील इन फेवर ऑफ द लॉ मेकर कंसर्न्ड. Now see, there was a decision of the Honorable Supreme Court in the year 2018 by the name of Lok Prahari versus Union of India, जहाँ पे Supreme Court ने ये clarify किया था that the disqualification will not operate from the date of the stay of conviction by the appellate court. So significantly, the stay, it cannot merely be a suspension of sentence under section 389 of the CRPC. Section 389 जो CRPC का है, it provides, it empowers an appellate court to suspend the sentence of a convict while the appeal is pending. तो ये जो provision है, this is akin to releasing the appellant on bail. And this is, अगर हम राहुल गांधी के केस में अगर इन सारी provisions की अगर बात करें कि what is his case has to do with all of these provisions, या फिर what is the ramification of these provisions on his case. So this means that he has to first appeal before the Surat Sessions Court and then he can approach the Honorable High Court of Gujarat. Now see, एक और provision होता था section 8 में, section 8 subsection 4, which is now declared ultra vires the constitution. According to that provision, after 3 months have elapsed, उसके बाद disqualification जो थी वो it used to come into effect, और ये जो 3 months थे ये दिए जाते थे ताकि lawmaker can prefer an appeal against the conviction. However, in the landmark case of Lily Thomas versus Union of India, Supreme Court ने इस provision को struck down कर दिया while the bench held that Parliament had no power to enact subsection 4 of section 8 of the Act, and accordingly subsection 4 of this particular Act, section of the Act, it is ultra vires the Constitution. So this was the legal framework when it comes to disqualification of an MP or an MLA after the person concerned has been convicted of any offence in any particular manner which is listed out in the Representation of People's Act. So with this, we've come to the end of today's TNA. अगर आपको free study material which is provided by LawSikho उसका access चाहिए, या फिर if you want to get access of the TNA slides, I would highly encourage all of you to join our Telegram channel using the link which is provided to you in the description of this video, or you may scan the barcode which is given here. अगर आपको LawSikho से contact करना है, these are the point of contacts, you may use the same. And the link for yesterday's TNA quiz, it is made available in today's YouTube video description. You may find the same, and I would encourage all of you to please attempt the same and make your preparation be up with it. Now, as far as yesterday's question it is concerned, though I would like to congratulate Priyal Gupta जिन्होंने उस क्वेश्चन का करेक्ट आंसर दिया, and the correct answer would be Article 134 of the Indian Evidence Act. The question for today is, by which amendment of the Indian Constitution, the 10th schedule which provides for anti-defection law, it was inserted? Please put down your answers in the comment section, and I would request all of you to highly participate in the same. Thank you for being with us.